Key items. Non-compete agreements are important tools used to restrict individuals or businesses from engaging in competitive activities after the termination of an employment or business relationship. However, there are several typical pitfalls and critical issues that can arise when drafting or enforcing non-compete agreements. Here are some common pitfalls to be aware of. Unreasonable scope and duration. Lack of consideration. Ambiguous or overly broad language. Unreasonable restrictions on employment. Failure to protect legitimate business interests. Lack of geographical and temporal limitations. Violation of antitrust laws. Inadequate consideration for changes in circumstances. Unreasonable scope and duration. Non-compete agreements should have a reasonable scope and duration that is necessary to protect legitimate business interests. If the restrictions are too broad in terms of geographic area, time period, or scope of prohibited activities, they may be deemed unenforceable by a court. Lack of consideration. Non-compete agreements must be supported by adequate consideration, such as providing the employee or party subject to the agreement with some benefit or compensation in exchange for their agreement to the restrictions. Failing to provide proper consideration can undermine the enforceability of the agreement. Ambiguous or overly broad language. Non-compete agreements should be drafted with clear and specific language to avoid ambiguity. Vague or overly broad language can lead to uncertainty and disputes over the extent of the restrictions, making it more difficult to enforce the agreement. Unreasonable restrictions on employment. Non-compete agreements should not unreasonably restrict an individual's ability to find employment or earn a livelihood. Courts may scrutinize agreements that overly limit a person's ability to work in their chosen field or industry. Failure to protect legitimate business interests. Non-compete agreements must be designed to protect specific legitimate business interests, such as trade secrets, confidential information, or customer relationships. If the agreement fails to identify and protect these interests, it may be considered overbroad and unenforceable. Lack of geographical and temporal limitations. Non-compete agreements should clearly specify the geographical area and time period within which the individual or business is prohibited from engaging in competitive activities. Failing to include such limitations can weaken the enforceability of the agreement. Violation of antitrust laws. Non-compete agreements must comply with applicable antitrust laws, as they may be seen as anti-competitive restraints on trade. It is important to ensure that the restrictions are reasonable and do not unduly restrict competition in the marketplace. Inadequate consideration for changes in circumstances. Non-compete agreements should address potential changes in circumstances, such as changes in job responsibilities, promotions, or business acquisitions. Failure to account for these changes can render the agreement ineffective or unfair. To avoid these pitfalls and critical issues, it is advisable to consult with an attorney who specializes in employment law or contract law. They can help ensure that the non-compete agreement is properly drafted, enforceable, and tailored to protect the legitimate interests of the employer or party seeking to restrict competition.